Overbreadth in medical practice acts poses a real threat to preventive speech, and today we'll explore why. Let's start with the introduction. State medical practice acts often use broad language to define what counts as practicing medicine. When these definitions include the word prevention, they risk chilling protected speech from unlicensed wellness professionals who simply want to share lifestyle guidance. Here's the core problem. If prevention is folded into the legal definition of practicing medicine, then everyday wellness advice, like recommending better sleep habits or nutrition changes, could expose coaches and educators to licensing violations, even though they're not diagnosing or treating disease. This isn't a hypothetical concern in just one or two places. A number of states include prevention in some form within their medical practice definitions, creating a patchwork of legal risk across the country for wellness professionals. Take Michigan as an example. Its statute defines the practice of medicine broadly, and that breadth is exactly what raises constitutional concerns when applied to speech-based guidance rather than hands-on medical treatment. Not every state takes this approach. Some states have created safe harbors, explicitly protecting unlicensed practitioners who offer wellness services as long as they follow certain guidelines and disclosures. Nevada's safe harbor law is a strong example. It allows unlicensed individuals to provide wellness services under specific conditions, so long as they avoid certain prohibited actions and make required disclosures to their clients. To understand why this matters legally, we need to look at the First Amendment. Several key court cases have shaped how we think about dietetic speech and medical practice regulation, and they set the stage for everything that follows. One pivotal case is People v. Rogers, decided by the Michigan Court of Appeals in 2001. It directly addressed the boundaries of the practice of medicine statute. The court's conclusion in Rogers was significant. It clarified how far the definition of practicing medicine could stretch before it started to conflict with constitutionally protected speech. Another important case is Cooksey v. Futrell, which involved a First Amendment challenge to North Carolina's dietetics practice regulations. This case reinforced that giving general dietary advice is different from practicing medicine or dietetics without a license. Now let's turn to a particularly detailed case, Richwine v. Matuzak, which dealt with a death doula operating under Indiana's Practice of Funeral Service Act. In this case, the district court had to decide whether funeral licensing requirements could be applied to someone offering guidance and support around death and dying, and whether that guidance was protected speech. The court examined the specific language used by the death doula and asked whether her services amounted to regulated conduct or protected expression under the First Amendment. Ultimately, the court applied intermediate scrutiny, a legal standard that requires the government to show its regulation serves an important interest and is no broader than necessary. The state argued that funeral licensing laws serve important interests, like protecting consumers from harm during vulnerable moments surrounding death and bereavement. But the court pushed back on that argument, finding that the state's justification didn't adequately address the plaintiff's specific speech-based activities, which didn't involve the physical handling of remains. So what does all of this mean for a growing profession like wellness coaching? Coaches often provide exactly the kind of speech-based guidance these legal cases were wrestling with. Wellness coaching has grown into a substantial industry. Market research shows increasing recognition of health coaching's role in preventive care and chronic disease management. Organizations like the National Board for Health and Wellness Coaching are clear about scope. Their certified coaches don't diagnose, treat, or prescribe independently. They support behavior change through conversation and goal setting. Part of the tension here comes from a mismatch in how prevention is understood. Conventional medicine often focuses on early detection through screening, while consumers frequently expect prevention to include everyday lifestyle guidance. Given all this, meaningful reform is needed, both through the courts and through legislatures, to clarify that speech-based wellness guidance is distinct from the practice of medicine. In conclusion, protecting speech-based preventive wellness guidance under the First Amendment isn't just a legal technicality. It empowers consumers with more healthcare options and supports professionals doing important, lawful work.